DM. Both parties are present via Zoom. It's a motion that was filed by the defendant father. I also have information that he had recent surgery, and the doctor has said to he's asked for it to be adjourned because the doctor says it's not appropriate for him to do important decisions this morning. However, I would point out that this is a matter of enrollment in school, and it's really West Catholic versus Rockford, as I understand it. The parties have joint legal custody. The parties don't agree on next year's school. As a result, there's really nothing to do except for set this for it's called a Lombardo hearing for the court to determine which school is appropriate. Mr. Clark, do you have any? I mean, I'll adjourn it for you, but basically all I can do with this matter, ma'am, is to set it for an evidentiary hearing.
I mean, in my eyes, it's not a Rockford versus West Catholic decision. It's more of a, I mean, I'm willing to have her go to West Catholic, but under the terms that she would have a court order saying that the tuition would not be paid for from my daughter's Social Security death benefit.
Good. If you guys can work this out, that's fine. But if you can't, then I got to have a hearing on it. I'm not going to.
Right. We can't
today. So,
right.
Ma'am, anything you wish to add very briefly?
Yeah, I just want to say that I've said in writing, and I'm happy to put in writing that her Social Security benefits would not be used for tuition. So I've been consistently paying for her tuition.
So file a stipulation between the two of you that you both agree on, a stipulated order that says whatever it is you agree to.
Right.
All right. So I'm assuming you're going to file a stipulated order. If that doesn't come in, you can renew this motion. We'll have an evidentiary hearing. That's all there is to it.
Sounds good.
Good luck. Thank you.
Thank you.
It's the matter of Jones v. Walkus. We have present Ms. Jones, Mr. Walkus, Mr. Clark. You can log off. And we have from the prosecutor's office, Ms. Michelle Smith-Lowe. This is seeking a judgment of paternity. I have reviewed the matter. Both parties are present. I think I said this already. Both parties are present as well as the prosecutor. I have a DNA test showing that Mr. Walks is clearly the father of the twins, as I understand it. They're 9 years old. There's 2 kids. There's a request to also enter a UCSO. Shows 0 overnights, gives mom's actual, dad's actual, plus provides some potential for father because he's not working full time. And Ms. Smith-Lowe, does that pretty much state what you're looking for?
It does, Your Honor. There is, I believe that Mr. Walkus, based upon my conversation with him during our pre-hearing conference on March 6th, does want to address the court.
All right, Mr. Walkus, what do you got to say?
I got like 4 questions to be real brief. First question to be establishing parenting time, visitation of some sort. How do I go
Really
about
separate
that?
issue, can't do it today.
Can't do it today. All right. Second question. Based on the paperwork, just for verification, the payment amount for both kids, I see $288 a month. Is that correct?
Mr. Smith-Lowe?
That is correct, Your Honor. We're asking for, that was based upon, as the court has indicated, the custodial parents' actual income, I believe, and Mr. Walk's actual income with an additional imputation because he is underemployed, but based upon past history and 0 overnights and no other children.
Correct. Yes.
Okay. Third question is, when exactly is the payment due date? After today.
The payments commenced as of this. We have a commencement date of 12/1/24. 12/1 of 24.
Well, I'm sorry. That should actually, Your Honor, that should be 12/1/23.
They actually start 12/1 of 23. You're actually in arrears, but they will collect those at a very minimal amount.
Okay, because I did ask that question, and I was advised not to make any payments until this hearing.
That's fine. Yeah.
Okay.
They're not going to arrest you next week because you're in arrears. Just start making your payments, and they'll include some for arrears. What else?
Now you said not today, but when will be the appropriate time to
It's up to you. You gotta file a motion or something to ask for some parenting time. It's not it's
Okay.
not something that the prosecutor is involved with. This is just to establish paternity and child support.
Mr.
That
Walks,
concludes my question.
friend of the court will contact you regarding setting up payment and what to expect once this judgment is entered.
Okay. Well, that concludes my question.
Ms. Jones, anything you wish to say?
Yes, I would. I did reach out to him in the earlier years of their life to be involved with them, and he
That's
stated that
fine.
he was too busy.
This is not
So
anything that I'm gonna rule on, so it doesn't make any difference.
that's
You wanna
fine.
Talk to Mr.
That's
Walsh,
fine.
and if you wanna talk to him and establish something between you, that's
I would
fine.
not like to talk to him.
So otherwise,
I would just like him to speak to you, if I may.
ma'am, there's nothing that you're discussing that's in front of me today.
Okay. Well, I would like to say that the income that I have is inaccurate. That was during my overtime period, and I don't make that right now.
Well, you were charged with $17 an hour for 40 hours a week. You aren't even being charged with overtime.
Yeah, but I'm not even hitting 40 hours a week now, and haven't been for the last 2.5 months.
If you wish to try and do something separate, Miss Smith Lowe, your thoughts on that?
Can you tell me what you are making?
I am making $17 an hour. That is correct. But I'm working about 30 hours to 28 hours a week based on our staffing.
Okay, that is probably a very minimal, and I can probably tell you very quickly what that difference is. That's a very, very minimal
Change, because the non-custodial parents does not really, or the custodial parents' income does not count very much in this.
Did you say 35 hours a week?
28 to 30?
Okay, and so I would have to be, because I don't represent either of you, I have to be fair to both of you. I'm imputing Mr. Walks to about 35 hours a week, so I'd have to put you at 35. Because
I understand.
that's considered full-time. So using the $17 an hour at 35 hours a week with no other changes, the calculation goes from $288 a month to one more click. Actually, $290 a month.
$2 difference?
$2 difference.
Not worth it. I'm gonna enter the orders that have been provided to me. If anybody wants further court involvement, they can file a motion. Thank you all
Awesome.
very much.
May I say something, please?
What?
I'm sorry?
What? I got a lot of
May I say
motions
something?
and I got a lot of motions. What's this about?
I would like to not have parenting time because I did
That's
reach out to
not
him.
before me.
and he
I've just
refused
told you,
it.
that's not in front of me.
Okay, I apologize.
Thank you. We're adjourned.
Thank you, Your Honor. I'll submit that with the change in the effective date.
Yes, thank you. Velasquez versus Gator Velasquez. Can both of you hear me? Jonathan, you're on mute. Are they connected?
I'm here.
You're on mute, sir. Miss Velasquez is present.
You're still on mute, John.
You're on mute. Ma'am, you can stay on. Why don't you just mute yourself? We're gonna call another case while he tries to get on here. Well, maybe he's here.
Oh, yeah.
Sir, can you hear me? You're on mute if you can.
I think he's probably connected on his car through Bluetooth, and so he needs to turn the Bluetooth off. I'm gonna work with him.
Just mute yourself, ma'am. We're gonna call another case, but I don't want to lose you.
All right.
All right. This is a matter of Sarek versus Mendez. Both parties are present via Zoom. The motion has been filed. Custody. Motion by the mother. The plaintiff, ma'am, you have custody right now. I'm not sure what you're doing. You're poking the bear, but you were given custody without prejudice in a judgment of support of 2/24/23, without prejudice to requesting a judicial finding of it. So all I can really do is set up a hearing.
Okay, if he wants to do parenting time, that's also okay. but I'm not sure if he will follow that.
Well, I have no idea. Here's a motion for custody, and I can set up a hearing for joint legal or for legal and physical custody, because that's what you asked for. There is no parenting time order at this time. This is you starting everything. So, that's fine. Mr. Mendez, what do you got to say?
I got nothing to say.
So do you want a hearing about that, ma'am? You've got custody. I don't know what you're getting at.
Okay, so basically I just cannot force him. It's just very stressful to try to get him to parent and be consistent when it comes to helping with our daughter. It's just hard to deal with him. It's just very difficult to co-parent with him. So I was looking to either set up like a parenting time where he has to follow a court order, because it seems like I have been trying.
First thing, you didn't ask for that in here. You asked for a custody hearing. Secondly, which was it's not a parenting time hearing. Second, you can agree to an order. You can come to the court and ask for a parenting time order. You realize if he gets every other weekend from Friday to Sunday and he doesn't show up, I'm not sure what I'm going to do about it. There's not much. Man, you're asking me to force him to be a good parent and be there at a certain time. And if he doesn't, well, then I guess you'd have to file some kind of complaint with a friend of the court or something.
Okay.
So
I have to go through them?
Well, I'm asking you, you've asked for a custody hearing. I don't think you really want one after what I hear now. Because you have it. There's no parenting time order whatsoever. He doesn't have any specific parenting time, and unless he comes and gets a specific parenting time, and he hasn't asked for that, there's nothing going on.
Okay. I'm sorry. I've never had to do this before. I have a 12-year-old.
You should
I've
go
never
to an
had to do
attorney
like
and
a
get some
court.
advice from the attorney. I can't give you advice.
Okay.
Mr. Mendez didn't have anything to say, so
No, I get my kid, but I can't deal with her. She just starts saying crazy stuff to me. I just don't have time for none of that.
So then you guys agreed to a parenting time order that you got to do it and figure out a place where you can exchange the child and be done.
The
Not
thing
then
is,
file a parenting time request. It'll be Mr. Mendez because he doesn't have any parenting time.
okay, so it would have to be him to file, because as of right now, he's not taking.
You can file, but I'm telling you, you filed for custody. All right. And obviously we don't want a custody hearing because nobody's asking for it. You're just trying to come in and ask for parenting time. What parenting time you want? Mr. Mendez, what do you want? Every other weekend from Friday till Sunday?
Yeah, I was getting on the weekend, but on Sunday I got to bring her back like sooner because I got to go to work.
All right. So till when?
No, that's not okay, because I also work and I figure it out.
All right. If somebody wants a parenting time order, they can file with the court. Otherwise, or go to mediation, go to the friend of the court and ask for help. But if you don't, I'm going to deny your request for custody hearing. And if you want to do something on parenting time, file a motion and ask for some kind of specific times. Good luck, everybody. Thank you. We're adjourned.
Thank you.
DM Blaskus versus Blaskus. Both parties are now present via Zoom. There's a motion by the plaintiff mother. Oops. Hold on. Got to get to the right note here. This is a motion by the plaintiff mother regarding child support. Says she can't afford medical insurance. Ma'am, you realize you are getting $53 a month towards medical insurance and $35 towards ordinary medical. I don't think you understand that. However, I'll listen briefly to something that anybody wants to say, but the last UCSO, the last Uniform Child Support Order was from October of, looks like 2018. That means that it's 6 years old, and I would refer this matter to the friend of the court for a child support review.
Correct. Actually, I think John has, what I wanted was our insurance premium is around $1,300 per month. So my husband was changing jobs, so we had a lapse. So I asked John to add the girls to his insurance, which I think he has now. Is that correct?
Yeah, I actually have papers right here that I can show. I know that it's still going to have to go to front of the court for review and everything. I just brought papers so that you can see.
It doesn't have to. People didn't ask that it go there, but necessarily. But I think it's a almost 6-year-old friend of the court child support order. May end up you paying more, sir, but the bottom line is it's all numbers. And
Yeah,
said.
I was just curious, since they did not have insurance on them, you know, hers was 1,200 and he's getting a new job. I did go ahead and add them already.
All right.
I just wanted, do you want to see any papers for that or anything?
No,
Okay.
it's what reasonable co-parents should do to make sure that the kids are insured.
Right.
So, I'll refer this matter to the friend of the court for a child support review. And this matter seems to be taken care of. We'll see what the review comes through, and you guys can decide at that time if it's appropriate or not. All right.
Sounds good.
Good luck. Thank you.
Thank you.
Take care.
Bye.
Number nine. Number nine. Number nine. Famous Beatles. DP. This is a motion filed by the defendant father. Both parties are on Zoom. Child support motion. It appears that there was a UCSO from 2016 where father is paying $279. He also had filed a motion in 2022 that was denied for change of custody. It's an old friend of the court order. I think it's appropriate that we refer this to the friend of the court for review of child support. Sir, your child support may go up, may go down. I have no idea. Both parties need to cooperate. Miss Paul, do you have a problem with it going to the friend of the court? We're just trying to set up an appropriate number, and it is a 8-year-old friend of the court order. So we'll send it there and see what's the appropriate amount. Do you have a problem with that, ma'am? Nope.
Not at all. I really don't know what's going on at this point. Just
nope.
I'm over it.
He's asked something about child support. I'm going to send it for child support. We'll see what happens with it. Both parties get notice of it, and you'll be expected to cooperate with the friend of the court. They'll come up with an appropriate order.
All right.
I think so. Are you gonna say something or what?
What do I need to say?
He doesn't need to say, and don't be talking to her. You're talking to me.
Yeah, because when we come over to this when we came to this this opportunity for to come to the court, we have type of agreement about this.
The only thing you filed for was child support, and I'm not going to sit here and ask you what your rights or tell you what your rights are regarding if you pay child support and stuff like that. Go to an attorney. That's what attorneys are for. I'm not here to give advice. I'm here to follow to enforce them. We're going to send it to the friend of the court for child support. Anything else you can deal with an appropriate motion, but this isn't an appropriate motion for anything other than child support. That's what you filed.
Okay, so what's the main point to come to you, and if you're not going to do anything?
I'm doing something. I'm sending it to the friend of the court because you don't like the child support.
I didn't say that I didn't like child support. Just like I'm paying child support for the kids, but we are sharing custody. We are co-parenting. You know, I'm not denying.
You didn't file for that, and I don't give advice on that. That is a completely separate. You need to go to an attorney to figure out what you're doing, because that's completely different than what you filed. Good luck, everybody. I'll send it to the friend of the court for a child support review. That's what he requested. Thank you. We're adjourned. 5DM, both parties are present via Zoom. This is a motion filed by the father. Two separate motions, one regarding child support, one regarding change of schools. First, regarding child support. I don't know what you're saying. You have a change of marital status. That doesn't mean anything as far as child support goes. There's a UCSO that's only, what, 8 months old, uniform child support, that was agreed to by both parties. That apparently in that order has 208 overnights. You're saying you have 4 overnights and she has 3. That's what was taken into account in that. It says his sales job and the economy is slowed. Sir, I'm here to tell you right now that we don't take the last couple months to find out it is. You'd have to you guys agreed on something less than like 8 months ago. As to what it is, you can't say my commissions have dipped in the last few months. I'm not going to really consider that. It's got to be over a long period of time. What are you asking for?
Oh, I was just saying that it actually dipped in the last year, since everything happened when we claimed.
But you agreed to it less than a year ago.
Yeah, because I didn't know that was going to make less money. So, and then obviously I'm making less money, so I figured I'd try to see if I can get that changed based on the income coming in now.
Ma'am, What do you want to say? The other part I'm just gonna get rid of right now is there's apparently some request about change of school. I can't do anything other than set a hearing, although I think I'd set it for mediation first for the two of you to go to the alternative dispute resolution center, see if you can figure something out on that. Is there any reason that, what are we dealing with on change of school?
Neither parties live in the area. We both live almost an hour away from the school.
That's what I understand.
Kids are traveling, you know,
Yeah.
getting up at 5 o'clock in the morning and travel time. It's just
Yeah,
unacceptable.
they should complete this year there. And
Oh,
then
of course.
from that time on, you both been doing a good job. I think I should send it to mediation. The only other thing is to set it up for an evidentiary hearing and both of you come in and fight and bring evidence and all that kind of stuff. You want to go to mediation? What? Go ahead, ma'am. Sorry.
I'm sorry. I was just going to say, we've discussed it at length and we're mostly in agreement as far as what we would like. He mentioned, they're currently attending their previous school district, and we had agreed to them attending his school district now, and changing the schedule slightly to accommodate both of ours. So just changing the days. I believe that the only thing is in dispute is that I was asking that I would have more time with the children during the summer, since they would be spending the majority of the time with him during the school year. And they're over an hour away from us. So it's going to be more difficult for us to attend school events, etc. So I felt that having them a little more during the summer would be fair.
Sounds like it would be. Sounds like I shouldn't have said much of anything because you guys have kind of figured this out. It sounded to me, it sounds to me like he lives in Grand Ledge and you don't live in Grand Ledge, but he has the kids mostly during the school time. So quite honestly, it sounds like the only smart resolution is to send the kids to Grand Ledge. Because you don't want to drive them back and forth. So get together, file a stipulated order that says the kids shall attend such and such. And if she's given up some things, it doesn't sound like you're unreasonable. It might be appropriate if she's going to do some things that she gets a little bit extra time in the summer. If you can't agree on it, file a motion and come in and we'll set up a hearing and I'll figure it out. But you two don't seem to be very far apart, quite honestly.
We're not. It's just the summertime. I just feel like, I'm just going to miss out on, because obviously I got them to school time. I'm not going to be taking them out of school to go and spend time with them. And so getting them only 3 weeks out of a 12-week, summer.
I'm not trying to mediate this right now. A lot of people do week on, week off in the summer, quite frankly.
That's what I was trying to do. Yes, sir.
And then everybody, or 2 weeks on, 2 weeks off, so they can take vacations and stuff like that. But
sure.
You guys can figure that out. If you can't, come back and I'll either send it to the front of the court or make a ruling on that. Sounds like you've agreed on the schools. Yeah, I'll send it to the front of the court for child support review if you want. It's, the fact that your house costs more or stuff like that, that's not going to be considered. It's only going to be income and days and stuff like that.
Sure. Yeah, my income's just changed drastically. That's all. It's just,
you understand that if you're there are ways also that your imputed income if you go too low with it. So I'll send it to the front of the court for child support review. Expect that the two of you need to get together and write up a document. You can get documents here through the Legal Assistance Center. That will be a stipulation and order on what you do agree to if you're changing stuff so that it's in the court. Otherwise, somebody's going to come back later and say, well, wait a minute. He said I could have them every other week, but he didn't give them to me. And I'm going to say that's not in the order. I can only enforce court orders. Okay. I can't enforce agreements between the two of you unless it's a court order. So I would ask that you put in writing and an order where the kids will attend school. All right, because you agreed to that. I'll send it to the FOC for child support because you're alleging a significant change of circumstance since the last order, and figure out the summers.
Okay.
Right.
Okay.
And then
what?
Well, I was gonna say, I don't know if Haley's gotten the vehicle out of my name or not. I checked. It just came to my attention about this court order that the vehicle is supposed to be out of my name in 30 days. Is that something I gotta remotion if she doesn't get it out, or is that something we can?
It's completely paid off.
Oh, because I got something
So
in the mail.
it
And I just talked to him, so maybe it just didn't process through then because it still shows that it's on my account.
Make sure,
Okay,
I mean,
yeah, I
he
don't,
should be able to contact you and ask you a question like that, and you should be able to say, yeah, it's paid off, I'll get you that kind of stuff. You guys work together better than most that I'm having here today, so just
good.
That's good.
We're trying.
try. It's a tough situation, but I'm sure you'll do it, and if you can be, remember that it's all about the kids anyhow.
Yep,
Yes,
exactly.
we agree.
All right, good luck, thank you very much. We'll send it to the Friendly Court for child support. Yes.
I'm sorry, just really quickly, you mentioned earlier, ask for a stipulated agreement and fill out what we agree upon.
Yeah, it's a stipulation and order. You should probably can get it online even.
Okay.
And it'll be a form where both of you sign it, and it's a spot on there for the court to sign, and you can send it into my office if you want, Office of Referee Craig Frederick.
Okay,
And
thank you.
And then I'll sign it, okay? Because you guys actually get along on that. Thank you very much.
Okay, thank
Good luck.
you.
Take care. Thank you.
Thank you.
Take care.
2-DM, both parties are present. Mr. Hybor is represented by you, Ms. Ballas, that's correct?
Good morning. Yes, thank you.
All right. This is a motion that's brought by mother to enforce parenting time and objection to an ex parte order. First of all, I don't see the ex parte order in here, but I assume it gives father like extended parenting time or something. Is that correct, Ms. Ballas?
Yes, that's correct.
And that the basis for the claims is that the father, the plaintiff, believes that Hunter, one of the 10-year-old child, was abused by mother's boyfriend. I don't have any police reports, CPS reports, or anything on this matter. And I'm not in a position to make much of a decision on this because I don't have anything. Mother, of course, disputes that the boyfriend, or whatever I want to call him, has done anything inappropriate. What do you want to say very briefly?
I did get a copy of the police report back between the timing of sending my response to the court. I know that the police matter is dismissed, that they're not forwarding charges to the prosecutor for this. I do not have any information from Child Protective Services at this point. I'm aware that Ms. Church went to the school Wednesday, May 1st, and gave the child medication, which is a concern because he's already taking medication with the father. So it could have been easily a double dose of the same medication, but that's all the information I have.
Ms. Church, what have you got?
I brought Hunter's medication to school because when Mr. Hybor picked him up, he didn't have any medication with him. So Hunter has gone without medication now for 2 weeks. So I brought his medication to the school. And yesterday, Hunter's bus accidentally dropped him off at my house, and Hunter said that Dad told the school that he is not to take any of his medication.
How does this move the ball forward in your request?
I was just verifying that. I have interviewed with CPS. CPS has been at my house, done a home visit. They have interviewed Justin Jones. The CPS worker has given me her name and phone number to pass along to you if you needed to contact her.
Don't contact CBS. That's up to others. That's up to you to get information to me.
Okay. But the allegations to CPS, from what the CPS worker told me, is that his allegations were that Hunter was grabbed by the arm on his forearm and escorted down the hallway, and that he had a pea-sized bruise on his forearm. And then to the courts, he said that Justin assaulted him and held his arms above his head, yelled at him, his arms were bruised. Then in his response to my objection, he says that Hunter was thrown down the hallway. And from what the police told me, he reported to police that Hunter was just grabbed by the wrist. Literally, Hunter has behavior problems. He's in a special classroom with 4 teachers. He's put in holds to protect himself from hurting himself and others. And Hunter pushed me into a wall and then pushed past me and went to go into the kitchen, where Justin literally grabbed his wrist like this and turned him around and passed him off to me so I could put him back in his bedroom because he was having an episode. And now this has turned into Hunter was assaulted and all of these things.
Ms. Ballast, what are you seeking at this point for your client?
I'd prefer that extended parenting time remain in place until we do know the result of that CPS investigation, because I can't verify one way or another.
Or can I? I don't.
Occurred, and I just prefer that the child's safety be put first and the ex parte order remain in place.
And if the CPS says they're not going to substantiate, what do you plan to do?
I'll refer with my client as to whether or not prior orders will go back. I mean, CPS is the one who has the control over the situation, technically.
No, technically they don't yet because they haven't filed anything. They're just investigating.
CPS has tried to make a home visit with Mr. Hyber, and he's not getting back a hold of CPS.
I don't think that's true. He's contacted them multiple times so that I would be able to get in touch with them and verify the status of things.
According to the text message I received yesterday, Mr. Hyber has still not replied and set up a home visit.
Have CPS call Miss Ballast also. She represents him. She can set it up also.
Okay.
All right. I'm just going to adjourn this matter for right now because unfortunately, I just don't have much information. Does appear that Hunter may be somewhat out of control and maybe he does need to be physically disciplined, not injured, not assaulted, not abused, but some physical discipline. And what's going on, I'm not in a position to say. I'm not here for the next motions. The next motion will be on May 31st. In the meantime, we'll come back on May 31st I think that's my next motion, isn't it? In the meantime, I'm not going to keep the child from mother all the time. I'm going to allow her every weekend. However, Mr. Jones can't be there unless you guys reach some kind of an agreement. I'll let you see him every weekend, ma'am, from Friday after school until Sunday at noon, but he can't be around Mr. Jones until there becomes some certainty with this. Understand? I just don't want to keep Hunter from you altogether. And
no, I completely appreciate that. I just want to note that this happened 2 years ago. He did the same thing because he wanted me to move. And again, he claimed that there was assault happening, and it took 2 months for me to be able to see my kids, and nothing was substantiated. It seems to be a pattern.
I'm in a position where I don't know what happened there. Okay. I'm not taking his side and I'm not taking your side. The judge issued an ex parte order and I'm kind of listening to what the judge says, and we got to get something a little bit more certain. And I'm not trying to get you to be taken from your son for the month of May, from after school on Friday until Sunday at, we'll say, I don't know, 3:00. You can see your son. I just, in acting in the best interest of the child, I have to say that Mr. Jones can't be around at any time during the time you have the child. And then let's see what we come up to. At least get you some time with your son.
If it's proven that these accusations are false, can we do something to prevent this from happening again?
I don't know. We'll deal with it at that point. Miss Ballast, if you draft a quick order on that.
I'd be happy to.
Every Friday, starting this Friday. I know it might be a little difficult to get him after school, and I'm sorry that if Mr. Jones didn't do anything appropriate, I'm sorry that I'm making him not be around. But if he's going to be around there, ma'am, the child is not going to go to you. Okay.
I will spend every weekend at my mom's house down in Amherst.
That's great. That's great. Thank you. Okay.
Yep.
We'll see something on May 31st.
Thank you.
Thank you.
Thank you.
Martinez Zarate versus Niola. We have the plaintiff, Miss Martinez, present, along with the prosecutor, Miss Rummel. This is for a judgment of support. Child's Rebecca. I have gone through the proposed order that allows for potential for mother. She's apparently 4 months pregnant and worked through till April, but has no intention of working until after the child. So I know that she was given potential income of $14 times 35 hours a week. Dad has actual income of $20 an hour times 40 hours. I've gone through the factors for a mother. I think they're appropriate. There's an order that is being submitted that calls for Mr. Noyola, who I don't know if I already said it. This was set for 8:30 and it's almost 9:25 and he has never shown up. We have I think the order is appropriate at $593 per month. My only question is, you have this effective 1 year ago, Miss Rummel.
Oh, that is a typo. I am sorry. I will correct that.
You know, I've had you and I've had your cohort, and both of you transposed the numbers on the year.
Something's in the air.
Yeah, there's something in the air because she started it like way later than it was in 24 or something. It was supposed to be 23 and that. So I just wanted to point that out to you.
Yes, thank you for catching that.
As a 4/1/24. Ma'am,
Yes.
do you have anything you want to say about this? It appears to be an appropriate order, where child support is being set for him to pay at $593 a month. Ms. Martinez, you're on mute, so.
No,
Okay.
nothing to say.
All right. I'll sign the order when you send it to me.
All right. Thank you very much.
Thank you for being on here, Ms. Martinez. Thank you. We'll get the order entered.
Thank you.
Good morning, everybody out there in YouTube land, Cheryl and Missy and all those people making some progress going through here today. Hope all is well. Sharon, how's California? Kopek versus Kling. Sir, can you hear me? Mr. Kopek is, I don't know. You're on mute. We have Ms. Kling, represented by Ms. Curlis, present right now. And he is it show he's connected?
It shows he's connected.
Can you text him?
Yeah.
We're gonna text him, Your Honor, to see if he can unmute as well.
He apparently logged off. If you have another one, we'll leave them muted and see if he can. Well, wait a minute, he's connecting again. Both parties are now present. Ms. Curlis is on behalf of the defendant. This is defendant's motion that does not in any way follow an appropriate motion filing point 2.119. All I have submitted to me is a stipulation and order for parenting time, no request, no and child support. There's nothing to indicate why I should change parenting time or anything. So it's completely an inappropriate motion according to the court rules. I do have a response from Ms. Curlis that because this is a request kind of for parenting time, that apparently the father has completed all 3 phases of the phased in parenting time, and that something may be appropriate. However, unless the parties say something right now, and even if they do, they should file an appropriate stipulation. Mr. Kopic, this just isn't an appropriate motion. It doesn't ask why, it doesn't say why anything should be changed, and I'm not going to take it orally because it's supposed to be written and notices to be given to Ms. Kling. Ms. Curlis, anything you want to say?
At this point, I did speak to Mr. Kopek yesterday on the phone. I asked him if we could come to any kind of agreement based on what we suggested as a proposed change in parenting time. And he had mentioned to me that he would just like the court to decide today.
Well, the court is going to deny his motion because it's an inappropriate filing. And I'm not in a position to make, I don't know why I should change parenting time. Quite honestly, I don't know. There's nothing in here to say what the reason is. So I'm going to deny the motion. You, Mr. Kopek, should talk to Ms. Curlis and see if you can come up with a settlement. If not, you can file an appropriate motion pursuant to the court rules 2.119, and I'll deal with it at that time. Good luck.
Okay.
Thank you.
Thank you. Thank you, Aaron.
First time I may be going faster than my clerk can get stuff ready.
Take a minute, take a breath.
She's so used to me going so slow that she has All right, plaintiff is present. How did you get notice of this to Mr. Forrest? Because he has not been present, even though it's set for 8:30 and we're at 9:30. Did you send him notice of this motion?
Yes, I sent him a notion on a restricted delivery, the green card here, and he did sign it. So
When did he sign for it?
he signed, like when did he sign for it?
Yeah, when did you send it? When did he sign for it?
I don't know what the date is on here. It says, I'm not sure. I sent it the day I sent the motion out. So
Yeah, I mean, was it sent out on 4/16?
yeah,
And that's when you mailed it to him, was 4/16?
yes, the same day.
All right, let me just look here for a minute. And that would be more than sufficient notice to him. He apparently is just not showing up for it. This is a motion from the plaintiff to begin child support payments. It says enforcing beginning child support payments. Back in 2021, June of 2021, the friend of the court sent through inappropriate child support order or a request for a UCSO. Nobody did anything to get it enforced with the court. Prior, it says right in there when it was sent to you, ma'am, that you have to file a motion with the circuit court or the to adopt it. I mean, they are not just sending something through. The notice clearly is straightforward to you. The parties may enter stipulation or order, things like that, but it was not just automatically going to be in there, and it's stated in the document that they sent to you.
Yes.
Is for 3 years later now, and you want to enforce. I don't have a problem with starting child support payments, but the amount that's in there seems to be so outdated, because it looks like it was potential income for you. Do you work now, ma'am, or not?
Yes.
And I mean, his income was based on unemployment and also COVID related benefits, which I'm sure he's not getting COVID related benefits some 3 years later.
Yeah.
I think the best thing to do is to refer this to the friend of the court for an amount. I don't feel like I can go back to 2021 because nobody took any steps at all to have this entered. I will start it, you filed this motion on 4/1/24. You filed it after that, but I think it's appropriate to start it then. Let's refer it to the friend of the court so that they can come up with something more current.
Okay.
Right, and you will then make sure you cooperate with him. He might not because he doesn't cooperate here, but we'll get to the bottom of it. And once they send something through, we get it started. All right.
Okay.
All right. I just don't think the last one is probably very valid after 3 years.
Yeah, that's totally understandable, and I'm more than willing to cooperate with that. Is there anything that I need to do on my part? Do I need to call a friend of the court?
No, we're going to send a notice to them to start this review. All you're going to have to do is cooperate with them when they send you notice and stuff like that. Okay.
Yep.
Good luck to you. Thank you very much.
Thank you.
7DP. Both parties are present on Zoom. This is a request from the mother. I'm just getting to my notes. A request from the plaintiff mother regarding change of domicile. She states that her husband is in the Army and stationed at Fort McCoy in Wisconsin and would like to be able to move there. The father opposes that move. Is that correct?
Yes, it is.
The only order that seems to govern in this matter is a July 10, 2023 order that gives physical custody to mom and doesn't state anything about legal custody. Has not been determined. Ma'am, I sympathize with you, but I think the court has to have an evidentiary hearing. If he opposes, there's no finding of sole legal custody to you, or to anything like that. So I think we're going to have a hearing to determine if you'll be allowed to move. Is there anything you want to say? We'll get it as quick as we can.
No, I just want the fact that I just want it put into fact that I don't disagree with there may be some dates missing, but I want it known that the dates that are structured are the only dates that he's had our kids.
Well, that'll come out in the hearing, okay?
Okay.
I mean, I don't know what went on before there was a judgment of paternity, because there was only a paternity order back in July 10 of 2023. I don't even know if he had I don't know what he had to do with the kids before then.
Seeing them like he just, one of them was paternity to my ex-husband. So he was seeing them all along, all those dates that you have accounted for, he was seeing both of them.
All I'm going to tell you is this: I've got to have an evidentiary hearing to allow you to move, because there is not a clear legal custody with one party or the other. When you come in here, it's going to be a formal hearing where evidence will be taken. If you have proof of something, it's going to have to be submitted through an appropriate way. You know, you can't just hold someone up and say this. It's got to be admitted, it's got to be shown to be valid and all that kind of stuff. Same to you, Mr. Kosla. If you're going to come in here, it is very important that you have attorneys represent you, because otherwise I don't think either of you knows what to do in an evidentiary hearing. And an evidentiary hearing is a formal hearing. This is more informal, where everybody kind of just talks. Okay. I would suggest that you have one. The court will make a determination as to what is appropriate if they're going to allow a move. Ma'am, there are 5 factors called Diana Frio that may be applicable in there, and you should make sure you know those, because those are what tell me whether or not I should allow somebody to move or not, as well as the best interest factors, whether there's an established custodial environment, all these things. And that's why I'm telling you, I don't think either of you know probably what I'm talking about. And so you should at least consult with them. There are a lot of good family attorneys, and I would ask that you do that. We will get an evidentiary hearing as quick as we can. I mean, it's not going to be in the next 4 weeks, but we'll get one as quick as we can so that we can make a determination one way or another. Okay?
Yep.
Anything else, sir? All right. We'll set up an evidentiary hearing. You'll get notice. On that notice, it's going to tell you when you have to exchange documents and when you have to exchange witnesses and trial briefs and stuff like that. Again, that's something that I'm telling you, you probably don't really understand it, and you're going to have a tough time following it. But I have to follow formal rules once we have an evidentiary hearing. So good luck. We'll send you notice of it to, don't tell me your address, because we're on YouTube, but ma'am, are you at 167?
Correct.
And sir, you're at, looks like, just so we know where we're sending notice. Good luck. You'll get it in the mail, and please be ready when you come in here. Okay. Good luck.
Right, thank you.
Thank you. Greening versus Boyer. Ms. Greening is present. Mr. Boyer is also present on Zoom, as well as his attorney, Mr. Browning. This was Dad's motion to modify parenting time. There's been some custody orders in the past, late as 7/14/15, I think, was the last judgment of custody, or there was a consent custody order also on 3/16/15. I believe both parties have joint legal and physical. It sounds like during this time that the father has moved out of town, but back in town, and would like some type of a parenting time order. I don't think there's a specific parenting time order at this point. Father's also submitted other requests that were denied on 8/1. I believe there was a motion to modify. In 2022, father filed a motion for change of custody. It was denied. Sounds to me, Mr. Browning, like the one thing that needs to be done is set a specific parenting time schedule when I go through everything. Is that really what I'm looking at?
Yes, Your Honor. Previously, the plaintiff and defendant had an informal arrangement, is my understanding, and they were sticking to that, and that is recently broken down. So now we really need to get something firm and in writing and a court order, or else I don't think that we'll be able to do that, that they will be able to agree on anything amicably.
Ms. Greening, I'm going to tell you one thing. I read your response. Basically, you say child doesn't want to see dad. He's only 11. That's not his choice. I'm just going to warn you that right now.
That I have a letter of support from a clinical psychologist saying that he doesn't believe that the child should be in his custody.
I don't have it, and
I'm happy to submit that.
well, it's not submitted and it's not here today, and Mr. Browning doesn't have it.
That's correct.
Man, I'm not going to deal with something that Mr. Browning hasn't even had a chance to see. And I don't know why that would be there, but father gets a chance to be father. And I don't know what that even says, I guess. So what are you looking for? Ms. Browning, you're saying no parenting time for dad at all?
Not lately.
Currently, I don't.
Wait.
No, I meant,
myself?
all right.
I think he meant Miss Green.
Yeah, I meant Miss Greening.
Okay.
Currently, I don't think that it is in Hazel's best interest by any means. I think that it's unsafe for her to go there.
Why?
And Hazel has expressed a lot of times when she's there and there's abundant drinking happening and partying. She says there are inappropriate conversations. She's being completely neglected in the basement, just babysitting essentially her father's wife's niece. She brought her phone over there because her father explodes quite often in outbursts of anger, and she needed it there for protection. And she had it there for protection, and she was texting me, pleading with me to come and pick her up because she felt unsafe after her father's wife went through her phone and she no longer felt that she had that protection there. I have witnessed his outbursts and they are terrifying. I have asked Hazel before, what do you feel is going to happen? And she says, I think that he's going to hit me. Barney also has a flight risk in my opinion. He had a breakdown many years ago and left all of his belongings overnight, left for Seattle where he has friends and family there. He accused me of kidnapping and sent police over to my home. And the kidnapping word also is highly frightening, right? There is no kidnapping happening. The police were here, and that further upset Hazel. If this is any sort of change in custody, I'm not sure about Vadvarka, and I would like to.
It's not a change in custody. I've already stated that up front. It's to modify parenting time. I'm not going to change custody. It's not really a request to change custody. It's a request is when I go through everything to establish parenting time in a court order so that it will occur at certain time, certain way.
The child is frightened, and if there is, I will be fighting this forever. If there can be some sort of social worker involved, but she does not at all feel comfortable going there.
All right. Mr. Browning, any final words? I'm tempted to allow supervised parenting time until the friend of the court. I'll refer to the friend of the court for a parenting time assessment. They can go through everything and follow through all the documents and whatnot and what has and what hasn't happened. But until
well, Your Honor, she's making it sound like Barney's making some wild allegations of kidnapping when actually all he's referring to is he was on parenting time and Miss Greening came by and made
it doesn't matter. Yeah, that means nothing.
Okay.
Well, he didn't kidnap and he didn't kidnap.
Right. Okay. So on to another issue. They have been mutually agreed on a weekend and one night a week parenting time for years. And now, when did that stop? That stopped about a month ago. Is that right, Barney? That stopped, oh, yes, April 4th, all the way until April 4th of this year.
Is that correct, ma'am?
It has been highly disruptive having Hazel go there on Wednesday evenings.
That's not my question.
She goes there and she's neglected. She doesn't do homework there.
That is not my question. My question is that the way it has been until April 4? That's a yes or no?
Yes, it has.
All right.
He lives 45 minutes away. This is not
45 minutes away is not that far. That's not even the Lansing. I mean, 45 minutes. I'm not talking that he's taking the kid to Chicago. Mr. Browning, anything else?
No, Your Honor.
All right, I'm gonna change what I had thought I'm gonna do. I'm gonna send it to the front of the court for a parenting time evaluation. In the meantime, the father will be allowed Wednesday from 4 o'clock till 7 o'clock. And along with this, Mr. Browning, you're gonna draft this. There will be no alcohol consumed prior to, and I'm saying, 8 hours prior to, or at any time during any parenting time that is being there. All right, none. I'll also allow every Saturday from 10 a.m. to 7 p.m. I'm not going to allow overnights right now.
Every Saturday or every other Saturday, Your Honor?
Every right now, because I'm not giving them any overnights, and you were giving them Friday and Saturday overnights.
On every other weekend.
I understand, but he was getting Friday, Saturday, Sunday. He was getting more time that way. He was getting every other week. He was getting Friday, Saturday, Sunday. He was getting 48 hours. I'm only giving him 9 hours. Twice. That's 18 hours.
Could we keep it to every other Friday? Her being away, she's not going to be able to participate in sports. She's not going to be able to participate in friends' birthday parties.
What sports does she participate in?
She plays tennis right now, and she's starting other sports soon.
School sports? School's almost out.
There will be school sports. There will be school sports next year when she's in 7th grade.
Well, by then we're gonna have all kinds of information by then. I'm not gonna let this last till next year at school. We're gonna send it to the friend of the court and see what's appropriate. I'm not allowing
every
overnight.
single Saturday right now. So right now she has plans coming up on Saturdays. She's not allowed to be with her friends on weekends.
Yeah, she does every Sunday. She can spend all day Sunday, and she can spend Saturday night from 7 o'clock.
Oh.
Would you rather be every other weekend from Friday till Sunday? That's your choice. I'll give you that much. Ma'am, I got to have an answer. I got a lot of motions today.
Yes, every other Friday, Saturday. I would absolutely request that this be supervised as well.
By who?
I don't know.
Well,
I think my client could abide by no alcohol on Friday and Saturday.
There will be no alcohol if he's having every other weekend. Sir, if there is any hint that there's alcohol anywhere there that you're drinking it or whatever, I don't even care if your wife is drinking it. All right. If anybody's drinking in that house when you've got parenting time, I'm going to stop it altogether. Now, I know you're shaking your head, yes. So I assume, Mr. Browning, you know what I'm talking about. You do this enough to know that if I get any hint that there is truly alcohol in that household being consumed 12 hours before or at any time during the parenting time, he's going to lose it altogether. All right?
Yes, Your Honor.
Wednesdays 4 till 7 and every other weekend, Friday at 6 till Sunday at 5 o'clock.
I'm sorry, could you repeat that since I'm writing the order?
Every Wednesday 4 till 7 and every other weekend from Friday at 6 o'clock till Sunday at 5 o'clock.
I have a quick question, Your Honor. Would that include this weekend? Would I be able to see Hazel this weekend?
No, it's going to start next weekend.
Okay.
Because I'm going to give Mom a chance to at least prepare her and stuff like that.
Those weekends are now out of balance.
All right. Do you want it to start this weekend? If you want it to start this weekend, I was being nice, but if you want it to start this weekend.
I'm sorry, Your Honor. She has plans this weekend now.
Okay, then she can go the next weekend. It's one weekend or the other. I'm not going to put it off for 4 weeks.
Could it start in 2 weeks? She has a sleepover tonight with her friends, and next weekend we have plans with family with my father who's in the hospital.
It will start this Saturday at 10 o'clock in the morning. She can have her sleepover. This weekend will be the only one. All right? This weekend it'll start Saturday at 10 o'clock.
With an overnight?
With an overnight. He's going until Sunday at 5 o'clock. Then the next weekend he doesn't get it, and then it goes from then on Friday through Sunday.
Okay, and this
And
will also be
every
reviewed by
Wednesday.
friend of the court.
And I'm referring it to the friend of the court. I will do that. Each of you is going to be responsible to pay the $150 for the friend of the court investigation. If you don't and the other person pays it, I'm going to make you responsible, believe me, no matter what. You understand?
Yes, Your Honor.
This weekend only. It'll start at 10 o'clock on Saturday. Got it? Mr. Browning, I'm counting on you submitting an order on that.
Yes, Your Honor, you'll have it today.
All right.
And pickup and drop off will be at the child's place of residence, correct?
Yeah. You'll pick up from him and he'll pick up from you. You understand that?
I'm sorry, the pickup and drop off will be at Hazel's home, correct?
What have you been doing right now?
We've been going to Lowell and that doesn't work for her.
What do you mean? What doesn't work for her?
For her to have to be carted to Lowell and then back. And it's honestly, I never agreed to it. I've just been doing it as a courtesy.
Then it is going to be the person getting the child will pick up at that home. You will pick up at her home, Mr. Boyer. Ma'am, when the parenting time is over, you will pick up at his home. Then she doesn't go anywhere.
And on Wednesdays, they will pick up and drop off here.
Didn't say that. I said each party is going to be responsible for the pickup and drop off.
So I'm driving out to Portland every Wednesday.
Sounds like it. I don't know where he lives.
He lives in.
Yes, Your Honor.
Thank you. It's only temporary until we can get something through the friend of the court. Good luck. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Your Honor.
3DM. It's pretty straightforward. That the motion is by mother, Ms. Palma, asking for the father to sign the appropriate documents so that his daughter can continue counseling with Ashlyn Lister. Ma'am, you submitted a letter by your daughter. I don't read letters from kids. I don't know under what circumstance they're sent and whatnot. I'm just warning you right now. However, Mr. Palma, why aren't you signing this?
Your Honor, the last time we spoke, there was an issue with me not being informed or involved in decisions on the care of my children. And this is another example of that.
But you don't think she should continue to go to her counselor?
I reached out to my daughter and I tried to get information from her on why she needs counseling, and I'm getting no information.
You don't think she needs counseling? You don't think she needs counseling?
I'm not sure she does. I don't know. I don't understand why she needs the counseling. I've never been told why. I don't.
Have you ever tried to contact the counselor?
Yes, I did. They would refuse to talk to me.
Ma'am, what can you tell me about why the counselor won't talk to him and why she needs counseling?
The counselor won't give him specifics about.
No, the child's being protected through the counselor.
Yes.
I have a letter here that appears to be, has been under my care.
That's the pediatrician letter.
All right. But the pediatrician basically says that wants some counseling.
Yes.
But it sounds good enough to me, sir.
I disagree with the care that she's getting from the pediatrician. She's on meds that I don't agree with. I wasn't involved with that decision. She was removed from school without my knowledge until a month later. I called the school to find out what's going on, and the story I got from my daughter and my ex doesn't match the story I got from the school. I'm just trying to get to the bottom of all this, and I agreed to the counseling on the condition that I know what's going on.
You have joint legal custody?
Yes.
Contact them. A counselor is not going to really talk to you. Some of it is confidential. I mean, you got to understand that. I mean, if you go to a counselor, you don't
I understand
everybody just talking about it, all right? But you can certainly contact the counselor, Ashlyn Lister. Say you have joint legal, ma'am, you got to make sure she understands that too. You understand that? And, you know, and dad wants to know some about what's going on or what's in the best interest or why she needs counseling. But in the meantime, since you're not willing to sign it, I will order that, Jordan, continue counseling with Ashlyn Lister as, Ms. Lister deems appropriate. And we'll send that order through. That should be enough, I would think.
Yes,
Court order.
it is. It is.
If you're blocking Mr. Palma, or if they're trying to block him off of certain things, it will not go good for you, man. All right. But and I'm not saying you are. All right. I'm just saying, and sir, if you want to follow up and things like that, you have the right to do that. You have the right to know what pediatrician and geez, oh Pete's, you can come in and make a motion that says she's, but I'm going to follow doctor's recommendations. Man, I'm not a doctor. And it sounds to me like you're just almost being an obstructionist. But I don't know. Well, I'm going to order that Jordan be allowed to continue counseling with Ashlyn Lister. We'll send that order out to both of you. You can deal with it. And sir, you just got to, if you're concerned about this, then get in there and figure it out.
Sir, he was notified March 11th on why she needed counseling. I told him the doctor's name, gave him a link, and told him that she
2
was
months
having.
after the fact.
No, it wasn't 2 months.
It started on 1/15.
No, February.
Yep.
No,
Okay.
February.
I'm not going to resolve this here today. I'm going to order that she be allowed to continue counseling with Ashlyn Lister until further order of the court. If you want to figure stuff out or you want to file things, sir, that you think are appropriate, I'll deal with those at the time. But I'm not going to stop counseling because
Any
you
of my
find something.
court-ordered parenting time, she's not following the holiday schedule.
That's up to you to file. That's up to you to file the friend of the court and try and enforce it. I mean, you wait until you come in here and then you're going to claim a whole bunch of stuff. Follow through. If she's not allowing parenting time, you file appropriate things with a friend of the court. I mean, your daughter is almost 17, isn't she?
Mm-hmm. Yes. She is 17.
I mean, I don't know how much more you think the court's going to do. She's 17.
The court order in the divorce says she's supposed to remain in Forest Hill schools, and she was removed without my knowledge or permission.
And did you file anything with me to do
I'm
anything
trying to get
about
to
it?
the bottom of the reason, and I'm not getting any answers.
Then spend your time getting to it, but she's going to be 18 by the time you get to it. I'm just going to issue this court order. And anything else is appropriate. If you want to send something to me to do something, that's fine. But you know how much control I have over a 17, almost 18-year-old child? About as much as you do. So
that's why I haven't filed it.
All right. Good luck, everybody.
I have a question on that paperwork. How do I get that to the counselor?
Take it to her.
Well, no, I mean, how do I get it from you?
We're going to mail it to you.
Okay, cool. Thank you.
Good luck. Thank you. M. Kent B. Kent. Mr. Kent is here, represented by Mr. Engman. Ms. Kent is present. I had an appearance, I thought, from Ms. Striegel, but you are not having her as your attorney. Is that correct, Ms. Kent?
Yes.
All right. This was a motion. Says for change of parenting time, but what you're asking for is more than change of parenting time. You're asking for significantly more overnights, which would have to meet Vidvarka, Mr. Engman.
In the bottom down here, like a low horn that has.
Color up. Mr. Kent, Mr. Engman, you realize, I mean, basically you want the kid all during the school week with her having some time on the weekends. Right now it's 50-50. That's a significant change and must meet Vidvarka for change of custody for your request. Can you hear me?
I can hear you.
I know you can.
Sorry.
Mr. Engman?
No, Your Honor, I cannot hear you.
I can hear you. Can you hear me now?
You can hear us, though.
I can hear you.
Okay.
Can you hear me? Ma'am, just, if you'll mute for a minute, we're gonna take a different one while he works on getting in here, but don't leave. Just go ahead and mute yourself for a minute. And we'll see if we can take another matter in the meantime.
That's mute. Now,
Flakes v. Perry. Apparently the plaintiff, you say, did log on for some time, but then logged off, apparently working in healthcare. She is not present. This was set for 8:30.
Yes, that's correct.
Hold on, I got it. Was set for 8:30. She was only on for a very short time and then off. Apparently knows about this, but I don't know why she's not here. This is the father's motion regarding child support, sir. This is just, child support was set less than a year ago in a UCSO. And you're not, what is the change of circumstance from that to current? I mean, you're telling me that you have other kids. How many other kids you have?
So this is two more after the child with Miss Flakes.
Yeah, 2 other children. You were given $2,000 credit for having other kids.
No, I was not.
Yeah, you were. It says additional children adjustment, $1,939.
Haven't received any money from anybody. No.
You don't get that. I'm saying in the calculations, you were given credit for having other children already.
Okay, it didn't seem like it.
Well, if you read it over, and she was given credit for an additional children also, an additional child, and you were given credit for that. So
for two children,
sir. Yes, apparently. The credit you're given is $1,939 off of your income if you were for additional children. You didn't read the UCSO and the attached documents.
Yes, I did. I didn't see that, or maybe I didn't receive all of that.
Or maybe you didn't understand it, but you were given a lot. That's a high amount for 2 other children. You don't have additional children since this was sent out.
No, but I have additional children besides the 2 too.
I understand. And if you're paying support or something on them, then you have been given credit. So it's clearly been given credit in there.
Okay. Me and Ms. Flakes had an agreement, and she's not able here to back me up on this, but we didn't want to for me to pay child support because I do get my daughter. She's been trying to do it through the court system, but I don't know what's going on.
Well, and you say consider other life changes. I have no idea what that even means, and is not something that is considered in child support. Child support comes your income, her income, overnights, whatever, additional children, things like that. It is put into the computer, boom, spits it out. How many overnights do you have with the child?
I have more than half of the year. I get her all the time.
For overnight?
Yeah, and if she was here, she could vouch for that. We wanted to get something in writing today, if possible, but she wasn't able to come because of work. But like I said, she's been trying to go to the court and get them to stop the child support because it doesn't make sense for her to get it. And if I'm taking care of my child, is what we both agreed on. And from my understanding, from her, she's not even receiving child support. From my understanding, she's not getting like an actual amount of money.
Well, if she is receiving state assistance, I'm not going to change any type of child support to 0. That's for sure, because the state is entitled to reimbursement. I don't know what it is.
She doesn't get state assistance. From what she tells me, she doesn't get food stamps, maybe just Medicaid. But Kalia's on my daughter's on my health insurance too. I pay health insurance on her too.
Well, then make sure you get Medicaid off. I don't know what she gets. She's not here. And there's nothing here I mean, you can't come and say we agree to pay 0. If you do, and you meet the appropriate requirements for it, go to the front of the court and the 2 of you show up there and figure out what you're supposed to do. But I'm not going to change it right now. Not based on anything that I have here. Because you are given a lot of credit for other kids.
And I never seen where it says I get credit. You being really rude, man. I hate having to deal with this, man.
I'm telling you.
No, you're not.
I'm reading
No, you're not.
right now. Additional children adjustment, $1,939.84. Just because you don't see it, I can't help it.
Am I able to reschedule this since she's not here? We did want to know that too. Can we reschedule this hearing?
You can schedule it again. I don't care. I'm just telling you at this time, I'm not going to grant you.
Okay, well, I heard that part. Can we reschedule? You have the authority and the power to reschedule. Yes or no?
You can reschedule. You can file another motion if you want.
Are we done, sir? This is ridiculous the way you're acting, man. This is terrible.
Thank you. We're adjourned.
This is terrible.
I don't know what I'm supposed to do.
I have no idea what's going on.
You might have to.
Mr. Engman, can you hear me?
That's a brand new cell phone. I do not know how to use that one yet.
Mr. Engman, can you hear me?
Special place I go to on Zoom.
You can renotice it for our next hearing time if you can't get on. 18-DS Jones or Lewis v. Jones. We have both parties present, as well as Miss Curry representing the plaintiff, Miss Jones. This is Dad's motion. He says it's a motion regarding custody, and he spends a lot of time the courts to consider a review of this case since one has not been done yet. In the total income, which is all child support, has nothing to do with custody. Sir, what do you? I'm lost. What is it you want?
I'm asking for joint legal and physical custody. Right now I have parenting time, but I have it's limited to 3 hours per week. I have Tuesday morning and Thursday morning from 9 a.m. to 10:30 a.m. and every other weekend.
And every other weekend?
Every other weekend, yes.
I thought you said you only get 3 hours.
During the week, Tuesday and Thursday, I have an hour and a half on one day and an hour and a half on the other day.
That's prior to you going to work, is that?
Correct. Since then, my work schedule has changed. I have a very flexible work schedule. My supervisors and managers, they're willing to adjust my schedule according to my parenting schedule. I have Mondays off. I spoke with the plaintiff about adjusting the parenting schedule, and she doesn't want to cooperate with me on that. So I'm just asking, of course, if I can get joint legal and physical custody.
And I know what you're thinking is joint legal and physical custody. That means you get 50% of the time, and it does not.
No, I'm not thinking that. I'm not trying to change his environment. I'm just trying to get more time with him.
Ms. Curry, what's your response?
Thank you. Referee Frederick, this is a confusing case because so many motions have been filed by Mr. Jones. Your temporary order regarding parenting time was just entered 6 weeks ago on March 26th. This is the second time he's filed a motion, I think, regarding custody on a case that just started. But I think looking at the judgment of support, as you know, it says in those judgments that mom has physical custody, that it's silent as to legal custody, and that any time within the first year after it's entered, the friend of the court can look at a parenting time schedule. You already sent one, but I'm assuming the court may send it over there to look at joint legal custody since there's been no determination regarding that. And but there shouldn't be a reconsideration of physical custody at this point. Nothing's been filed on that. And they can also look at the parenting time schedule.
This is originally filed as a DS case.
That's right.
And the DS case, if I can find the order, always says nowadays that initial custody is granted to the mother without
right.
prejudice.
The judgment is February 23rd, the judgment of support and the USO.
The judgment says mother has initial custody of the child without prejudice to determination of either parent's custodial rights. All right. That's, I mean, there is no judicial determination. If he wants to, motion for temporary relief. If he wants to have a hearing in custody, it doesn't do anything regarding parenting time. That's the part that the court is in February 23, 2024. That's what it says. And he wants joint legal and physical custody. And quite honestly, it says in here that the initial custody of the child without prejudice to the determination of either parent's custodial rights. I'm by definition, I got to have a custody hearing. Not that it changes anything unless the two of you can agree on something to submit. As far as if you're willing to say, I don't care, you can have joint legal and physical custody, you can submit that and that's fine. But that's what it says in here. And I have set up an evidentiary hearing for it.
That's fine. There was another motion filed and heard, it looks like, on March 22nd by you, which was another motion regarding custody. And what came out of that is the order for parenting time that I believe the court drafted.
Every other weekend, et cetera. Yeah, and it was just because it was pretty clear to me that Mr. Jones is interested in getting time with his child, and the custody matter was not, I don't know what I want to say, an issue really. He wanted time, and I gave him every other weekend, Saturday at 9 through Sunday at 6, and every Tuesday and Thursday 9 to 10:30.
Right.
And that is going to be the order moving forward on parenting time at this point. However, because I don't have anything to change parenting time other than I want more parenting time. And sir, I don't know what you're thinking is more parenting time, but anything like that would start to disrupt an established custodial environment, and you have to meet a standard that's pretty high. Although I'm just going to have a custody hearing on this. Nothing's going to change as far as parenting time at this point, but I know you know what, Ms. Curry, what I'm talking about, but I don't know that Mr. Jones does. Parenting time will remain as set. We will set up a custody evidentiary hearing to determine what is appropriate. Ms. Curry, you may want to talk to Mr. Jones about allowing joint legal or something like that.
My client's Miss Lewis. Thank you.
All right. I don't know.
Mr. Jones, right?
I don't know what I said, but Ms. Curry, I'm talking to you. You may want to talk to the parties and determine as far as the custody arrangements go, joint legal, joint physical. And as far as that, if that is determined, the evidentiary hearing for custody will go away. All right. And Mr. Jones, if you're coming in asking for significantly more time, we'll deal with it after the evidentiary hearing for custody. So I've just got to set up an evidentiary hearing for custody because he's saying he wants joint legal and physical, and he's got the request, and pursuant to the order in there, it's without prejudice to either party making a court determination. Mr. Jones, you're going to be at a extreme disadvantage if you don't have an attorney, but Ms. Curry is very adept at this. So we'll set up an evidentiary hearing. Ms. Curry will make sure that you are available. Mr. Jones will send a notice to you to see when it's set up for. Other than that, I'm not making any changes to any orders at this point.
Okay. As far as picking up and dropping off, right now I'm responsible 100% for picking up and dropping off, and that doesn't make it any easier on my schedule. Like, I tried to work out something with the plaintiff, but like I said, she refused to work out anything with me, like as far as the simplest things. So is there anything that can be done as far as...
How far are you guys apart?
About 15 to 20 minutes, depending on the traffic. And I only get an hour and a half with him. So it's like, we don't even get a chance to do anything. Like, we in the car, we might go to the grocery store, and I bring him back, and we sit in the car.
Okay, at the time, I didn't have a car. Now I do.
You didn't tell me.
Well, Mr. Jones, don't argue with her. Just contact Ms. Curry, and you guys can settle some of this.
Yeah, and that's why I suggested the friend of the court, Your Honor, but we can try and do it outside of that if you prefer.
Yeah, I prefer, because if I send it to the friend of the court, it'll delay it 3 months, and then Mr. Jones isn't going to be happy unless he gets a lot of time. And we're just going to have a hearing.
All right, well, I can certainly talk with my client, and then he can communicate with me.
Good luck. Mr. Jones, communicate with Miss Curry, all right? She knows what she's doing. If you can get an attorney, you better get one, all right? And then Miss Curry and your attorney can talk and probably resolve this. But I'm going to set up an evidentiary hearing. Right now, I'm not going to change anything. Miss Lewis probably says she can do a little bit of the transportation. I'm not making it part of this right now. We'll get to the bottom of it. at the evidentiary hearing. Good luck, everybody. We'll get those notices out to you. Make sure that you follow what's in there, sir.
I will.
There's a
Okay,
motion
thank you.
filed by each party, one by the defendant mother asking for change of domicile to Idaho. The other by defendant father to enforce. All it really is saying he doesn't want him to move the residence to Idaho. Mr. Klein, you understand that you do not have legal custody?
I do, sir.
Which means that she basically gets to make these kind of decisions on her own? What kind of, Ms. Klein, what kind of contact does Mr. Klein have with Lola and Timothy? How often?
He really has no contact with them besides when it's beneficiary for him. Just over spring break, he's been asking for, he changed the custody, like the visit time, not the custody, sorry, the visiting time. And he's asked for like spring break, which this year he was granted spring break. He has not contacted the kids or anything. Our son Timothy had reached out to his dad one day and said, "Hey dad, can I come to your house?" It was during spring break, and Mr. Klein said, "Oh, I'm out doing Uber right now. I can't come get you. If you give me an hour, I can come, or I can call you and let you know
I
I can
kind
get
of read
you."
that, and then he didn't. Okay, but I mean,
Yeah.
how often does he see the kids this year?
This year, he's seen them maybe about 3 times.
Mr.
This year,
Klein,
not even.
Mr. Klein, what is, you don't see the kids very often.
Every time I call over to the kids, like on a Thursday, I want to make sure if I'm going to get them Friday, I call and speak with my son Timothy, and he says, "Dad, I don't want to come over today," and I'm like, "Okay, that's fine."
Well, he can call you from Idaho. You can call him in Idaho and have the same amount of contact.
Yeah, I would just prefer to have the kids in the same state, so it'd be benefit for both kids to have both parents in the same living state.
But you don't spend any time with the kids. So if they live in the same state, what's the difference?
I could go to their house 30 minutes away instead of 2,000 miles away.
But you don't, and you haven't for years.
It's because like every time I call them, or I call my daughter, or text my daughter on the phone, and I tell her, I say, "Tell Bubba and you to have a good day at school." And when it was my weekends, I would call on Thursdays and make sure I was getting them. And Mrs. Klein says, "Oh, well, I'll let you know." And then when the kids come home from school, the kids like, "Oh no, not this weekend, Dad." But then there's weekends I have.
So why didn't you enforce parenting time? Do you have parenting time with them per the order?
Yes, I do.
Why didn't you file complaints with a friend of the court?
Because I did not know how to do that, Your Honor.
Well, look at if I'm divorced and I don't get a chance to see my kids, even though they're there, I don't sit back and just say, "I don't know what to do." The court's here all the time. The friend of the court, you know, you got a friend of the court and all that kind of stuff. I mean, that's just giving up. That's just not even making the kids a priority.
Just this past weekend, Your Honor, after he filed the motion, he didn't call. It was his weekend. He didn't call to see if the kids wanted to go or anything. Our daughter had became so distant with him because he's not constant in her life. And
Assuming he
she feels
doesn't
like
make any
second option.
decisions, he doesn't make decisions for the kids. The kids don't
No.
look to him for discipline or, I mean, when was the last time you worked to their school, sir?
That I couldn't tell you, but I tried to call.
You know who their teachers are?
Yes, I do get an email from the teachers on their report card. I tried to call their school to see how they're doing in school, and the only answers I get from the school is, "You have to talk to the mom."
You don't have legal custody. You've never attempted to get legal custody. You don't play a part in the kids' lives. And as such, I mean, she gets to make the decisions. If you were a big part of their life, we'd have to have a hearing before she could move. But I'm going to grant her the right to move because she is the only one with legal custody. You don't play a significant part and have not played a significant part in their life. It would not disrupt an established custodial environment in any way, shape, or form if they were to move out there. Now, you can come back and ask for some time, you know, what to do when they're out there, ma'am, if he comes into me, I'm going to give him some time with the kids, like coming back here and stuff like that. You ought to talk to him about how he can see him in the summer or spring break or something like that, because that's the kind of stuff I would give him. But because you just don't play a real part in their life, because it does not disrupt an established custodial environment, because you do not have legal custody and have never sought to get it. It's just something that you've let go, and just like the idea that I call and they say they're not coming, so I just doesn't show a commitment, and because she does have legal custody, there is a statement in there that says the court would have to approve moving out of the state. I approve it because at this point there is no legal custody by the father. It would not in any way disrupt an established custodial environment. And so I will issue an order that grants permission that you can move out of state. I will tell you that I might put in there that the parties must work together so that he can have the children. You got to send them back or something, some during the summer when they're not in school.
Yeah, I went to Mr. Klein's house to try to resolve this out of court and everything. And I told him I would pay for summer, but I would have to work around my son's ABA schedule, which I could figure out once we get there. And he was just calling me all sorts of names and not trying to listen to me at all. I even said, any child support that you do pay, I will keep on that card. And if you want to come visit your children, we could use that child support to get you there or get them back. But I will also put money in for them to come see you.
All right, well, I'm going to grant you permission. And if you can't figure out something, sir, you can always file a motion for some type of parenting time. If you can't figure it out. Good luck. Thank you.
Thank you.
Tell Mr. Engman to renotice that I'm not going to make Miss Kent hang around any longer. Mitchell v. Hall. This is the motion by the defendant father regarding child support. There was a UCSO just entered less than a month ago. That had appropriate information. Dad had reported he was earned $15 an hour, 35
Want you to redo the motion for the 31st?
I was misinformed by the director of hire that I was going to be working 35 hours a week, and I barely put 20 hours a week, sir.
And you got to go out and find other hours, because they're just going to impute it to you. You can't have child support based on 20 hours a week. You got to go out and work.
But it was at my previous job.
Yeah, but now you got a new job or something?
No, I don't. This is still the same job. I just don't post 35 hours a week. I try to. I push for that, and the most I push for and get out is 20 hours a week. And this is me calling and trying to pick up shifts. Right. I didn't quit my last job. They terminated me before my 2-week notice. So I went 2 weeks unemployed before I even started working. Started working the 9th of April, and I haven't put 35 hours a weekend yet. I've only put 20.
Sir, I'm going to tell you the realities of life here. You have to work and pay child support. You have to work full time, which is 35 hours a week. If you're only working 20, then you got to find a second job, because I'm going to impute that to you anyhow. I'm going to, even if you don't work it, I'm going to say that unless you have a physical disability that is documented by a doctor saying you can only work 20 hours a week, you've got to go out and work 35 or more a week. And you're only being charged at $15 an hour. Mom's income is imputed in there, or what she makes. Mom's income doesn't really affect child support very much. We just had one earlier that, I don't know, mom made $100 less and it changed it $2. So that isn't very effective. You have to work, and you're only being charged every working 35 hours at $15 an hour. I don't see a change of circumstance that would warrant a change in the order that is not even 1 month old. So I'm going to have to respectfully deny your motion at this time.
So me not having a place to reside doesn't count towards that either.
That isn't something that's in the UCSO. That isn't considered in that. Child support doesn't say stuff about where you reside, how much you spend for a car, or how much you spend for a house, or whatever. I mean, there are jobs out there that you can work at $15 an hour. There are many out there. Go to McDonald's, Wendy's, all these things. You can work $15 an hour and easily pick up 20 hours there to supplement your others. It's just something, you got a child and you got to support the child. You just got to
understand that, referee. I can go through the resource for parents program and get a better income.
Do anything that you can. All right.
Because yeah, I can't afford this child support, and you won't even lower it due to the
can't. There's nothing in here in the law that allows me to lower it. Just because you say I can't afford it is not enough. It's something that you've got to do, and the state holds me to it. The state tells me I'm not, that's the law. I can't just say, okay, well, yeah, I know it's hard. That isn't a reason.
I gross $11,000 a year. That is my net income.
But you're not working full time. But you're not working full time.
Yeah, I understand that.
All right. So that's not an excuse. I'm going to have to respectfully deny it. Ms. Mitchell, I didn't ask anything of you, but there really isn't anything to say unless you want to give him some kind of a break on your own.
Well, that's the thing. I've been doing everything for our daughter before she was even born.
Hey.
He has not helped me besides getting this child support in order.
All right. Good luck, everybody. I have to respectfully deny your motion, sir, and we're adjourned. Thank you.
Can parental time be established? Because I have not seen my daughter.
I can't. That's not the motion, and it has to be a separate motion to establish parenting time. You can't just come in and say,
I gotta pay child support and I can't even see her. I'm being denied being able to see her.
I'm just telling you what the law is. You can listen to me.
The law says
that
I
child support
run my
motion.
daughter if I'm paying
You
child
filed a
support.
child support motion. I'm not here on parenting time. She was not given notice of a parenting time motion, so therefore it's not in front of me. I'm not going to hear it. Thank you. We are adjourned.
Objection. I just want to see my daughter. It's not about parenting time. I need to see my daughter. I haven't seen her. I'm paying child support for some
We're
being
adjourned. We're adjourned. I can't argue it here. Thank you, Ms. Mitchell. We got somebody here. Ms. McKee, can you hear me?
Yes, I can.
All right. Mr. Stokely is connecting. Ms. Paletta, can you hear me? You're on mute, so I don't.
There we go. Okay.
All right.
Yeah.
Mr. Stokely is still logging in. I've called the case. Both parties are present with the respective attorneys. Mr. Carpenter for Ms. McKee, Ms. Paletta for Mr. Stokely. Mr. Stokely is still logging in. This has been father's motion through Ms. Paletta to enter a UCSO. We got to get one entered in this case. Mr. Carpenter, what's your position?
Your Honor, we provided my client's income information. As you can see from their motion, they're claiming that, I believe they're claiming my client makes between $15 and $50 per hour. That seems to be the breakdown. The UCSO should be based on my client's actual income. If they want to,
unless it's underreported or under.
But there's simply no evidence that it's underreported or that she has an unexercised ability to earn. They're simply not satisfied.
Did she file taxes for last year?
For 2023, I don't know what the status of her tax return is for 2023.
Ms. McKee, did you file taxes for last year?
No, I did not.
Why not?
I didn't make enough money. I wasn't employed long enough.
So how much did you say you made last year?
Last year, I only worked for about 2 months, and it was part-time, about $15 an hour through battle-tested security.
Mr. Carpenter, you understand that I'm probably going to just set this up for some kind of a case conference, whatever, but you understand that she's not going to be allowed to work 15 hours at $15 an hour every now and then. She has to have, I'm going to impute her, ma'am, just a minute. I'm going to impute her income because she has the ability to earn.
I understand that, Your Honor, and if we could have agreed upon a reasonable amount to impute her, we could have gotten this done. But they want to impute her at a substantially higher income than she has historically made.
I mean, I've heard before that she was going to be a stewardess or a flight attendant and all kinds of stuff.
And that didn't work out for reasons that you're going to hear about later this month, if because things continue to happen in this case. There's a motion to change custody that's going to be heard later this month because Mr. Stokely has been substantiated for child abuse.
Well, I'm not going to hear that now. And none of the we're going to get. You have the information, Ms. Paletta. I'm proceeding because your client just doesn't log on. Okay. And you
That's fine. That's fine.
And we've sent him several messages. So I think we ought to set up a time for us, the attorneys and myself, to have a settlement conference on this to figure out what it is. Mr. Carpenter, you understand that she's going to be imputed. I'm going to impute her probably at least at $15 an hour times 35 hours a week. That's full time. There's no reason she can't work. That's just my initial thought. I'm not guaranteeing it right now, but I'm giving you some information so that when we get together, you know where I'm leaning. All right.
And I appreciate that, Your Honor, and that could probably help both sides move towards.
Paletta, I'm not sure. I don't know her education and stuff like that. We'll talk about it. And if you think it should be different, we can talk about it. But $15 an hour nowadays is like minimum. I know it's minimum wage is $10.33, but I don't know of anybody who can't pretty much go out and make $15 an hour and work full time, which is 35, 40 hours a week. So that having been said, why don't I have my clerk call you guys after this hearing, see if we can set up a half hour or something to discuss this. If we can't get to it, well, I guess we can't reach something and you require an evidentiary hearing. I'll set up an evidentiary hearing. The child support is going to be retroactive to when this motion certainly was filed, if not before then. So keep that in mind also. It's way too long. We should have set up something a long time ago. Anything you want to say, Ms. Paletta?
No, Your Honor, just that this needs to get set. This is kind of silly.
And that's the quickest way. I mean, I just said an evidentiary hearing, but quite frankly, it's going to be out a ways, and I want to talk to everybody and give them some idea of where I'm going. These are numbers, okay? This isn't talk of abuse or this or that, or the child doesn't want to do this. This is numbers. So if you guys can agree to it before then, that's fine. But I'm telling you now that I can't imagine that I will go less than 15 an hour times 35 hours for her.
And we would be fine with that at this point, Judge.
So then talk to Mr. Carpenter. Mr. Carpenter, you guys talk to each other, okay?
Thank you.
We will call you about a settlement conference. You guys can let us know. All right?
All right. Thank you.
Thank you. Good luck. Have a good day.
You too.
Your Honor, they lied about how many kids they had on his uniform child support order, and I just wanted to mention I've set up a settlement conference. We'll deal with it at that time. Thank you. Okay.
We're adjourned. Just shut up and keep going. All right, Ms. Coletti, Ms. Van Dyken, I can see that you're connected with us. Ms. Bennett, Mr. Verbrugge, they're both on mute. I'm assuming that they can both hear. Parties are present with their respective attorneys. Ms. Van Dyken for Mr. Verbrugge, Ms. Coletti for Ms. Sims. This is the father's motion to again enforce parenting time. Says he shows up, the kid comes out, says I'm not going with him, and goes back in the house. I believe the child is 11, and this has been going on. He hasn't seen his child since December. It was clear at the last hearing that we had it, that I said I'm not changing anything at this point. We set up an evidentiary hearing primarily for determination of joint legal custody, but I have reviewed the request from Ms. Van Dyken, the response from Ms. Coletti, including a letter from the counselor for Lily, saying the child will go, and I believe the counselor has indicated that the child's said she'll run away if she has to. I understand this is not a child who can drive the bus, but I also have a letter from the appointed guardian ad litem, with Ms. Kirkstra, saying that, and it appears that she has heavily involved in getting to the bottom of some of the things, that she has indicated that she's got a couple more weeks probably worth of work to do to talk to all counselors and everybody involved. I think one thing she said was Mr. Verbrugge had not maybe given her a chance to talk to his counselor, but I'll leave that to Ms. Kirkster to take care of. Ms. Van Dyken, I've read your motion. I'm not inclined to grant it at this time. I do understand that.
Really?
Yes, because quite frankly, I can say that he's going to get makeup time when he doesn't get the time right now, is to say, okay, he gets every weekend. So every weekend he goes over there and takes it. I will take into account the fact that she is not visiting him at a time when there is a court order out there to do it. Whether it's appropriate or not, I don't know. What my intent is at this time to get Ms. Kirkstra's guardian ad litem report. And as soon as I get that, then you will get it at the same time as to call a case conference between the attorneys to see where we are going from there. As far as ordering the friend of the court to do their job, they do their job well. I'm not going to order anything with the friend of the court. Ms. Van Dyken, if you want to.
I would like to make a statement for the record, Your Honor.
And that's just exactly what I'm going to say. You may
Thank
make
you.
a statement for the
In
record.
the 60 motions that you've done this morning, many times you've told people to file with the friend of the court when they're not getting their parenting time. My client does that. Friend of the court is not doing their job statutorily. They answer to you. You should be forcing them to refiling these complaints and accepting them and doing the things that are necessary, including setting an order to show cause. This is unacceptable that we're letting an 11-year-old drive the bus. Miss Bennett didn't come to court and ask for a motion to suspend parenting time, nor she hasn't. You have court orders. You follow court orders, or you appear in front of this court and accept the sanctions that this court should be doing to Miss Bennett. I don't believe that this court can just, on this motion and the 60 others you've done, say, the kid doesn't have to go, I'm not going to enforce the order.
Didn't say that. Didn't say that, and don't tell me I did say it. I said there's a court order out there. I'm not excusing it, but we're going to have a hearing to do it. I've appointed a guardian ad litem. I'm looking at a significant amount of information way beyond just that. I'm going to get to the bottom of it. He may get all kinds of makeup time. He may not. I don't know what's going on. And so you didn't file an order. You want to file an order to show cause? We'll probably set it for some time out there. That's not what I said. And don't tell me that's what I said.
The court is not enforcing its own orders.
What do you want me to do? Tell me, you've asked for makeup time. The kid doesn't go now. So you want me to order makeup time? I will get to it in the end. In the end, you know that you can ask for a change of custody if she is wrongly denying this, and it comes that if she is alienating, you can ask, and that is a change of circumstance or proper cause for me to take care of and look at custody. I'm not going any farther today.
You're not enforcing the court orders, and you're not requiring the friend of the court.
What do you mean I'm not enforcing it? What is the enforcement you want? You want makeup time. I said I may give parenting time. I may give makeup, but it is stupid to order an extra weekend when she's not going anytime, and I don't know why. I'm going to get to it. I'm just delaying it now. Thank you. Do you have anything else, Ms. Coletti?
No, thank you, Your Honor.
That's the order of the court. We will get to it. When I get the guardian ad litem report, I will contact both attorneys for a prompt settlement conference to see where we're going with this matter. Good luck, everyone. Thank you.
Thank you.
I don't think I held my temper very good on that. Yes.
Okay.
It's a matter of Dong versus Deng. We have the defendant present with his attorney, Ms. Grauman. This is a request to establish parenting time, custody, child support, and tax exemption, basically. The initial order in this case, as it is a DS case, states that mom gets initial custody without prejudice of either party filing to establish custody. As a result, I'm without much, I don't think I can do anything except set a custody hearing.
Right, I understand that part.
And so I guess that's what I'll have to set as an evidentiary hearing regarding custody. And along with that will include parenting time, child support, and whatever other matters like tax exemption.
Yep, and then Your Honor, if you could keep things versus status quo as well. If in my motion, I explain in my client's affidavit that he literally takes care of the kids every day. So if we could just ask for the status quo to be maintained. My client is his new apartment. He won't get till August 1. He would have gotten a place a long time ago, but there's a civil case the parties are involved in right now where he signed off on the quitclaim deed. She was supposed to give him money from the house, and she never did. So
I don't, you know,
that's why it took so long. Is why I'm bringing that up for him to get his apartment.
Until we get to the evidentiary hearing, quite frankly, we'll maintain the status quo of the party's current practice.
Okay.
You can draft that order regarding parenting time. I know he says he's planning on purchasing a house, but that plans, who knows? I don't know when that'll happen. So the parties can maintain their current status quo until the evidentiary hearing. We'll send out notice. My clerk will contact you to make sure you are available for that evidentiary hearing.
Okay, perfect, Your Honor. Thank you very much.
We'll deal with all the other issues at that same hearing, okay, including parenting time and child support.
So custody, parenting time, child support, and the child tax, all at that hearing.
We'll deal with it all at that hearing.
All right, and
physical and legal and all that stuff, okay?
Sounds good. Thank you so much.
Thank you. We'll get an order from you.
All right, I will send that in. Thanks. All right, can I leave now?
I want to?
I actually get to go home after this.
All right, well, on your way. See ya. Have a good weekend.
You too, thanks. Bye.
It's a matter of, I hope I'm Marcial versus Toledo. Sorry if I'm butchering your name, man.
No, that's okay.
And this is a motion made by the father regarding parenting time. Apparently, the father's been out of the child's life for many years, 4 years or something, but he wants to start seeing his child again. And says that the son doesn't want to see him. He's only 5. He doesn't get that choice, ma'am. I'm sorry. The father has even indicated he understands he's got to work into it. He's not asking for overnight weekends and stuff like that, and I'm not going to give it to him to begin with. Sir, well, ma'am, I'm going to give him some parenting time, and I'm going to start out with some supervised parenting time that he's going to have to show up at regularly. And if he does, he will probably be able to work into more and more parenting time. It's just the way it is. I understand he was out of his life for years. He's asking to get back into it. He's provided me a lot of stuff about how he apparently has changed. It sounds like he had some substance problems or whatever. I got all kinds of stuff here that he filed that seemed attending AAs and counselors and all kinds of stuff. I'm willing to accept the fact that he's changed his life some and wants to start making a life with his son.
No, that's good. I'm happy to hear that. I really am. It makes me feel a lot more comfortable knowing that he has made changes. So I'm okay with him being involved with our son. And I also like the fact that it will be supervised for I don't know how long, but
well, to begin with, sir, I'm gonna have you supervised for about 2 months, 2.5 months, just to see how things go. Okay, let him get used to you. Now,
yes, sir.
Now, I don't know where we want to have supervision. I can do it at Journeys and they'll give me a report. It costs and stuff like that. And if you guys want to do that, that's fine. I don't know if there's any way that somebody who mutually agree upon you could possibly work with. He appears to be sincere in just wanting to be a father now. Is that a fair statement, Mr. Toledo?
Yes, sir.
Have you made some good changes in your life over the last couple of years?
I have.
Clean and sober?
Yes, sir.
I got a lot of stuff here, ma'am, that says this. Okay.
Yeah, I've been working hard, man, and I'm ready. I want to see my son. I want to see my baby.
I want you to be a good father, as does the mother. All right. That means you don't come in and out of his life. That means you're appropriate with him. And I'm willing to, ma'am, can you think of somebody who would supervise a couple hours a week with him, or do you want me to send him to a professional?
I think, to be honest, sir, if Mario has made those changes, if he's okay with being civil with each other for our son's sake,
I wouldn't mind. I think he has my number from the paperwork, where we can meet somewhere so that they have time together. Because I really don't have anybody that we both know mutual that will be able to help out.
Sir, I'm just giving you a possibility, all right? What about if you met every, pick a date and time, I don't care, every Wednesday for a couple hours in maybe at the food court at the mall or Denny's or just something like that. And it is important that both of you have to be civil. I don't know who's not said. You got to understand, I sit here and all the time and I hear everybody pointing saying they're the problem. All right. I don't want any problems, nor does your child. Your child doesn't deserve any problems. Your child just wants a mom and a dad now. So do you think you could, what would be a good spot where you guys could meet every, what day?
Yeah, I'm sure we could come up with something.
I mean, like,
when are they?
like every Saturday at noon or 10 o'clock or something like this at the food court at Woodland Mall, or if you want to, I'm just throwing stuff out. Denny's, McDonald's, that's, what do you think, man? Where, I don't know where you guys live to say what's a good place to be.
I am located in Wyoming.
He's in Middleville. I mean, wouldn't Woodland Mall work? Isn't that kind of in between you guys?
You can do either Woodland or Rivertown or whatever he thinks is best. I'm fine with. And if he wants to do his original parenting time like it was before, which were Mondays, Wednesdays, and Fridays, I'm okay with that. And maybe Saturdays, every other Saturday, if he wants to.
Well, why don't we do a couple of times where you guys meet and let your child get used to them? All right. You want to,
right?
If you guys are going to say you're going to work it out, I'll let you work it out. And if you can't, renotice this motion and I'll pick a spot. All right.
Okay.
Get together and I just hope you guys, why don't I adjourn this motion for till the 31st? In the meantime, I'm hoping that the two of you got her number, and can you be civil when you guys talk?
Yeah.
All right.
It's about my son now, so
Well,
I really want to see him.
Yes, it is about your son for both of you. All right. And if you disagree, you're allowed to disagree. Just be adults about it. All right. And set up some times and see if you can do that. And if you need to, we'll be back here on May 31st, and I will set times and where. All right. Won't be probably convenient for anybody, but let's do that. Is that agreeable to both of you?
Yeah, I agree.
All right. Then
yeah, that's good.
That would be great. You would be one of the few successes that I've had today if the two of you can actually get along and figure that out. All right.
Okay, sounds good.
Mr. Toledo, thank you, but I want to make sure that it's all about the son now. Nothing to do with mom. Okay. And same with each other. Good luck. I hope I don't see you on the 31st, but if I do, I do. All right.
I appreciate it.
Thank you.
Thank you. Have a good weekend.
You too. Bye.
Sorry.
Well, yeah, there is a problem with yours, and I'll tell you that up front. Is there?
So that's why I'm making
Well, and you see, there is not proper notice, so she's not here. I can't proceed.
Proper notice?
Proper notice.
I gave her proper notice.
No, you mailed it. You mailed it, and the date on the mailing was last Friday.
Yeah, I was told to mail it on Friday.
If you mail it, it has to be the Wednesday before, not the Friday.
That's not what the.
It doesn't matter. I am telling you.
So you're canceling?
Well, I don't know. We'll see. If she wants it canceled, I have to cancel it. I don't care what they told you, but it has to be mailed the Wednesday before.
I tried giving it to her.
I understand. I'm not just telling you, I've got to follow the rules. All right. If you hand it to her, you can hand it to her on a Friday and it goes on. If you mail it and you sent in the thing that showed that you mailed it.
She keeps telling me to give it to her mom and but
I would have to have you renotice it if she's not.
Thursday, they told me that as long as I hand deliver it or mail it, that's what they told me. And
they gave you bad advice. I know the court rules and they don't. So is she here?
Yeah, she's on.
All right, then we'll deal with it. Venta versus Peg, give it to me. Paguada, sorry. Ma'am, can you hear me all right?
Yes, Your Honor.
All right. This was a motion filed by, I was just talking to the defendant. A motion filed by him regarding parenting time, and I was just telling him that you didn't have sufficient notice if you wanted it adjourned, but you're here. Do you want to have it adjourned for a couple weeks, or do you want to proceed?
I just want to proceed. It's okay.
Right. Yeah, that's fine, because I mean, it's going to be the same thing in a couple weeks, the same motion, everything. All right. Thank you. Then she's waived any defect in service. All right. This is his request to modify parenting time. He's apparently in town for 14 days and out of town for 14 days.
Sir, I ended up not taking that job, just for.
So where are we at?
I'm still working at just a regular factory. Right now it's steel case.
So
So
what do you,
I was just wanted you to know for that.
yeah, what are you asking for then?
Oh, if anything, to just increase on parenting time. Right now I'm seeing him supervised 4 hours on Saturday.
From 10 a.m. to 2 p.m. every Saturday at your mom's house.
Yeah, and I just I provided the court with some information as far as
Where you're living.
where I'm living. I also just moved to a different place, right into Wyoming. I have pictures of room, pictures of a lease.
Let me ask Miss Venta.
I just moved in on Wednesday.
Yeah, you told me before, and you said again, you're gonna be getting a 2-bedroom apartment sometime,
Yeah,
but it hasn't happened.
I just have a 1-bedroom, and I have pictures. Can I show?
Is there a 1-bedroom apartment? You can't show me unless you've shown her first.
Okay. So I'm just asking for more time. So as far as my place goes, I know right now he says he's not comfortable staying overnights. That wasn't the case when he was a baby. I just took him for the weekend, and then it was every other weekend. But as far as I just wanted to see if I could get Saturday all day and Sunday all day.
Let me, not every Saturday and Sunday, because she's gotta have some too. So she can do things. So yeah, I know, but I know, but he's 7, he goes to school.
No, I know that.
And so if you took every weekend, she'd never have a weekend with her son. She's only got school time. So let me just ask her, ma'am, what are your thoughts on his motion? Do you want to give him some more time? He has been exercising pretty regular parenting time, correct?
Correct.
It's time that we give him a little bit more somehow, somewhere.
Yeah, of course. And he's asked me, and right now my girlfriend and her daughter live with us. So I watch her daughter and take her to school, and then she picks him up when they're out of school and then watches them until I get home. He asked me one day if he could come see him. And I said, of course, let me just check with the babysitter, her, if she has any plans. And he gets mad and he gets frustrated. So
let's just set some specific time. All right. The two of you can always agree or disagree, but sir, and I know you sent in stuff about how you asked for it. She doesn't have to give you other time. All right.
Being cordial with the court.
And I understand that, and I'm trying to, it's time for him to get some additional time. I don't know that he needs to be supervised at his mother's house all the time. I'm not giving him overnight right now, but is there a reason that he shouldn't have all day Saturday?
my son says a couple hours is fine. Could we do maybe like 6-7 hours?
Well, I think each Saturday he could have him from 10 till 7. That's just a Saturday.
Okay, so just Saturdays?
Can I get
Just stop. Let me run this. Okay, I'll get to you. Do you want to do every other Saturday and Sunday?
I was gonna say, can we do Sundays instead? Because of course, like Saturdays is when I'm able to take them out and do things with them. Or can we do like every Sunday and every other Saturday or something like that?
Every Sunday and every other Saturday?
Yeah.
He'll accept that. Yeah, no problem.
Can we do them like vice versa? Like if he has them one Saturday, the Saturday like that? Like, does that make sense?
I'm not really sure. You mean 1 week he has Saturday, 1 week he has Sunday?
Yeah, because if he has it every Sunday, then 1 week I won't have him at all on the weekend.
Oh, okay.
When?
So on that weekend, then I'll make sure that we can.
I'm not. All right. I'm not sure where we're at here now. You want you want this week, Saturday, all day from 10 till 7. Okay. Let's just say it's All right. And then next Sunday, you get them 10 to 7.
Mhm.
And then the next week you get Saturday 10 to 7. And we're going to get to the point here, as long as things continue to go good, that in the near future, if you want to renotice this motion instead of filing a new one, renotice after this has gone on, but not for 3 weeks. I mean, this got to go on for several weeks. All right. And I'm talking months. All right. If this works out and you guys can't agree, you can come in, and there is going to be a time when he's going to get like a weekend, every other weekend. All right. But we will do every other Saturday or Sunday. Which way do you want it this week? Do you want him to take Saturday or Sunday?
Sunday, because I think next week is Mother's Day. So
Oh, yeah, I want you to have Mother's Day no matter what. Okay. So this week, Saturday or Sunday,
This week, Sunday,
10 till 7.
and I can take them, pick them up.
Yeah, you can take him, pick him up, be
Can
appropriate.
can you add just a couple hours during the week? Cause I like to just stop by, see him. I got him a phone and stuff, but he lost this, or I guess he found it, but I don't know, sometimes.
Hold on. Next week, it's Saturday, 10 till 7. Can you see him on a Wednesday evening from, what time do you get off work?
Usually work from 5 a.m. to 3:30. So
All right.
As soon as he gets out of school, I'm out of work.
From after school till 7, just on Wednesdays. That's it.
okay.
And every Wednesday after school until 7 o'clock.
Since I won't be home, can he pick them up from my house and drop them off at my house then?
You will drop him off at your house. He can pick him up at school, quite frankly.
The school doesn't allow him because he's a registered. So the school has already not allowed property.
I used to pick him up from the other school and they had no problem with it.
Again, this principal has already told him, and the security guard and the police have already told him.
Look, I don't want to put the school at issue. I don't want to have
There's
to
no
fight
issue. I'm
over.
picking myself
What time does your child get home from school?
Around 3:45.
You can pick him up at 4 o'clock there and have him till 7. Just
I
work.
don't work till 3:30, so I'm not out right away, but yeah.
So you can be there at 4 o'clock?
Oh, yeah.
Every Wednesday, 4 till 7, and every other week, Sunday, starting with this Sunday, 10 till 7. Next week it's Saturday, the next week is Sunday, the next week is Saturday, just keep
So
working.
this weekend will be Sunday.
Sunday.
And the next weekend will be Saturday.
Yes. All right. You understand that, ma'am? Thank you for working with us. I really do appreciate it. All right.
Your Honor, can I just ask that next time if he can do it like a couple of weeks or months before he does another motion? I keep on missing work for this.
We'll see, yeah.
Okay.
Just
He can renotice it and give us a little while, okay?
They scheduled it quicker, so my bad. I'll let them know, because they asked me, they're like, can you do next week Friday? And that was on Wednesday,
Oh,
Thursday, and I
yep.
was like, if
We're
you guys
done.
can, I can.
All right.
Next time I'll make sure it's a couple weeks out.
All right. Stay in touch, be civil and tell her, hey, a few weeks from now, if we don't get anything more, we're gonna go into court and give her some time in advance. All right?
Okay.
Good luck. Thank you, everybody. Did a nice job. Thank you. We're adjourned. Just enjoy being a father and be a good one.
I'm good.
Thank you, you too. Nice flowers.
Thank you.
Are they yours?
Yes, they are. My husband got them for me.
Holy smokes. Stay with him. Was it your birthday or just?
I went on a ministry trip over the weekend and I came home and that's what he surprised me
Well,
with.
he had missed you, so that's nice. All right, if we can get Mr. Rodriguez in here. Matter, it's entitled Ortega versus Rodriguez. I have both parties present on Zoom. This is the father's entitled custody motion, but it's really not a custody motion. He's asking for parenting time. There is no specific parenting time order, and as such, I'm going to have to provide some kind of specific parenting time, because if the parties don't just get along with it, then you gotta. Father has asked, in effect, that for years he had from Thursdays to Saturday morning. It was stopped by mother. She was unhappy that he was apparently a legal medicinal grower of marijuana, was licensed. I'm just taking his word for it. And she didn't like the smell when the kids got home and all this kind of stuff. And she stopped it. Father then didn't take the kids to the home apparently for a period of time. I mean, these kids are 14 and 13, and I don't have hardly anything in the court order, which is good, in the court file, because they haven't had to come to the court very often to fight. Apparently, I think the kids went with you, sir, to Mexico over Christmas. I mean, it's not like she's denying you stuff. And now we've got to the point where he would like a specific order. I read your response. It's pretty clear that the kids want to have time with dad, but I got to figure out what kind of time. Is there anything you want to add, Mr. Rodriguez? You're really here right now asking, I think, for Thursdays through Saturday at noon, which you used to have. Isn't that correct?
Yeah, that's correct.
Ma'am, I'm inclined to do that, but I'll listen to why I shouldn't.
So the reason for that is because this change has happened over a year ago, and throughout the past year, Mr. Rodriguez has not made any very much attempt to have parenting time. I have offered parenting time. I told him that he can pick up the kids whenever he wants to, but he has chosen to only pick up the children maybe once or twice a month to go out to eat, and he will then drop them off, and then he basically will call. He won't pick him up any other time. So I have extended that parenting time to him. He just chooses not to. And he will pick up, ask to pick up one of our children and not the other.
And then as the court for an order that allows him to do that, and then that's the only time he would necessarily get, unless the two of you agree on it. I can't think of a reason why not to. I mean, these kids are 14 and 13. They're not little tiny kids anymore. And it seems like for a long time, that was the time. He's not asking to extend it or anything like that. I don't see a reason why at this point we can't allow him Thursday at 6 until Saturday at noon. And if
so,
that's all I'm asking for.
So if I can add to that, so Rogelio grows and sells marijuana in his home. And so it wasn't just the smell, but I mean, I'm not sure of how much he is growing in his household, and if he does have a license to do that. The children do come back smelling into their pores of the marijuana. And so I don't believe that is healthy for them to be around that.
Sir, what's your response to the marijuana? Because I mean, if it's a licensed business, I can't really stop it.
It's not that there's a problem, but about 2 years ago, she became a reborn Christian.
I understand. I'm not going there with it.
No, I understand that. But what I'm saying, it doesn't matter if there's one plant or there's 10 plants. She made it very clear that she does not want them around it. Licensed.
Are you a licensed dealer?
I'm not a licensed dealer. I grow what I am allowed to grow by the state of Michigan, and that's it. That's what I have. So
And
therefore,
here's my problem is that I mean, he could brew beer too, and if he wanted, and brew whatever it was that the state of Michigan allows him to, as long as he doesn't sell it and stuff like that. If he's following the law, I have a real difficult time of saying he can't follow the law and obtain his kids at the same time. Be aware of what her concerns are. I'm assuming you know that if you do stuff outside the law, you're subject to penalties. And if somebody contacts you and you're under arrest or something for going outside the law, you're not gonna have the kids over there at all. I mean, period. Let's deal with it appropriately. At this point, I'm going to allow every Thursday at 6:00 p.m. to Saturday at noon. I'm assuming that some of the other claims. Are you around a lot of that time for the kids? I mean, they go to school on Friday. I understand. I want you to spend some father time with them. All right.
Of course.
I don't know what you do for sure, but you have food and all this kind of stuff. Ma'am, I'm just not going to go against what the law says he can do. Like I say, he could, unless it becomes something that is inappropriate or difficult. Please vent your place enough so that the smell is minimal. Maybe you need to do something so that the clothes that the kids wear, if it maybe when they come there, have have them change and leave those at a place where they don't smell, and when they're going home, put them back into that or something. Be smart about this.
If I can make a comment on that,
You can.
so you can smell that as soon as you even pull up to his driveway. So this is why I'm thinking that he is having a lot more than what he's allowed to. I mean, the smell is so strong. He says he's got filters, but I mean, it is extremely strong. It is very hard to get out that smell, even from my house, from the stuff that they bring back.
There is a time when we harvest that it is a little stronger, and I can take that into consideration.
When you're harvesting and the smell is stronger, maybe you don't pick up the kids that week.
Exactly.
All right.
That's what I was going to suggest.
You got to be smart about this, or I will limit some things. All right.
I am okay.
I'm not, again, you know her concerns and you need to listen to them. I'm going to allow that parenting time because it's what you used to do. You know what the concerns are, and if she comes back, and the problem is, ma'am, I don't know what it's. I've never been to his house and don't know anything about the smell of it and stuff like that. Then I'm unlikely to ever go to his house to determine what it is. If things get bad, she'll be back and be trying to do things, and you know that. Until that time, I'll allow Thursdays at 6 until Saturday at noon. All right.
Thank you.
And you know what the concerns are. Don't
Yes, I do.
the envelope. Good luck, everybody. Anything
Thank
else?
you.
We'll send out the order, ma'am. I understand your concerns. And if he's going more than he's allowed to, it'll get to him. Thank you. We're adjourned.
Am I allowed to bring this to make a police report to have his home searched?
Ma'am, I don't tell you what you can or can't do on something like that. I don't know what, and I don't even know if you go to the police, whether they will or won't. I don't know. I'm not issuing any kind of order like that. I'm just issuing, whatever you want to do, you can do.
I just don't feel that it's safe for them to be over there with that kind of traffic. He grows and sells in his home.
He's saying he only grows what he's allowed to, and I don't have anything to show different. So at that point, we're Thursdays at 6 till Saturday at noon each week. Good luck. Thank you.